and gentlemen, we'll get going here and start by welcoming you to FrackingSENSE. I'm Patty Limerick from the Senate of the American West. And I'd like to point out that this event is made possible by a grant from the National Science Foundation Sustainability Research Network for a project on hydraulic fracturing and natural gas development. And I also want to note that the NSF does not endorse and is not burdened with responsibility for anything said in the series, including by me. We're grateful to our co-sponsor for the FrackingSENSE series, the Boulder County government. This is our third to the last FrackingSENSE talk this spring. On April 1st, we'll have Norman Werpinski, a world expert on what happens in the subsurface and the actual process and practice of fracking, hydraulic fracturing. And on April 15th, we'll have Josh Joswick, the former La Plata County Commissioner and a figure now in the Oil and Gas Accountability Project. I'd also like to point out that tomorrow, in a not FrackingSENSE event, Victor Masayev, a leading American Indian filmmaker, a Hopi person, will be presenting at 2 o'clock tomorrow, Wednesday, at UMC 235, showing his film Imagining Indians, and also a film he made with the Senate of the American West called The Color of Wilderness. So he is really an interesting bird, so consider coming to that. As usual, it is our priority to make sure that everyone who came to hear the speaker can hear the speaker. And so now for the usual FrackingSENSE request. If you disagree with the speaker, you may note your differences of opinion. We encourage that to convey your protest by sighing with exasperation or snorting with skepticism or even hissing with bitter disapproval or exhaling with exasperation. But you must stay within the boundaries of respiratory protest so that you do not disrupt your neighbor's ability to hear the speaker. We'll stick with our drill of having you write your questions on the little sheets in the program. Folks from the Senate of the American West will be walking around 15 or 20 minutes into the presentation, collecting your questions and bringing them to me, and also distributing more little sheets of paper if you need them. As to why we stick with this drill of written questions, I am still intoxicated with the fact that we can get our speakers to respond to a vast number of questions in contrast to the limited number of questions we can cover if we go for spoken questions. Our speaker tonight is Rebecca Watson, who is a shareholder with the law firm Welburn, Sullivan, Meck, and Tooley. For more than 30 years, Rebecca Watson has worked in the fields of conventional and renewable energy, mining, natural resources, and federal environmental law. She served as Assistant Secretary for Land and Minerals Management in the Department of the Interior in the George W. Bush administration, and she also served as the Assistant General Counsel for Energy Policy at the U.S. Department of Energy. Rebecca Watson is one of those rare experts who is able to remember what life is like for people who are not themselves graduates of law school. She is in truth one of the West's most effective translators of the technicalities of laws and regulations, and we are fortunate tonight that she will be addressing a topic that is often a great zone of mystery, the question of what federal law says and does not say about oil and gas development. She originated in Illinois. She made a full and total conversion to being a Westerner and would be unbelievably dismayed if told to go live in Illinois again, right?
Oh, no.
Oh, yeah. Lord, oh no, it's not going to happen. Not going to happen. And she is a very acute and alert and often humorous observer of Western American life. And so Rebecca Watson will be speaking on the question, is the oil and gas industry exempt from major environmental laws? And what about that fracking loophole? Rebecca Watson.
Thanks, Patty. Thank you. And let me know if you can't hear me or not. Is that good for the people in the back? All right, awesome. So I'm going to be hard pressed to make this topic humorous, but I will try and to translate it. This is a pretty technical discussion of federal laws that govern oil and gas production. And I'm going to try and cover a lot of territory. As you can imagine, the laws that I'm going to be talking about, there's about 16 laws. And I can tell you that each one of these federal laws could be the topic of an entire presentation, much less multiple days of presentations. I've gone to Clean Water Act wetlands presentations that lasted 2.5 days. So this is going to be a 40,000 foot level. That's what people always joke. Political appointees like myself, we love to operate at the 40,000 foot level. high up there, but I'm trying to highlight what the laws are and then what some new changes are coming about, so you can leave here with some new information. Oops. All right, I have to get this, all right, ooh, never mind. Aha. So, the foundation for the presentation. Now, people dispute whether Daniel Moynihan was the first one to say this, but I like Daniel Moynihan, and it was just St. Patrick's Day, so I'm giving him credit. He's often credited for this. And I think we've heard the governor kind of play off this statement recently, so I wanted to start with this. And I'm not going to ask you to believe in any kind of fracking facts, but just this foundational fact that in the US, we are a nation of laws, that laws matter. And you might say, well, that's kind of obvious. Why is she harping on that? Well, I say this because over the last year, the oil and gas industry has been doing some focus groups, testing messages and things with different groups, some mixed man and woman, some just men, some just women. And there was a picture and a discussion about the permitting requirements for oil and gas development. And they showed this beleaguered guy with all these piles of paper there, and they talked about the regulations that apply. And they said to the female focus group, does this make a difference to you? And the women said, no, the oil and gas industry, they can just bribe their way out of it, or they can lobby against it. Basically, that doesn't make a difference to us. So I want to start with 2 points on that. Number one, if that was the case, I wouldn't have a job. Because my job is to help people comply with federal environmental laws and public land laws and figure out how to comply with the law but still produce the oil and gas in an economical way. And the second point, if that was true, then there's no point in you sitting through this program, because I'm going to be telling you about federal laws that apply to oil and gas, and if you don't think they really apply, then what's the point of spending the next hour with me? So these laws are there, and they do apply in the US because we have a lot of different provisions. The federal laws are enacted by Congress. Agencies then promulgate regulations to implement those. And then agencies have enforcement authority. And then very importantly, citizen groups, environmental groups, industry groups have the right to come in and say, no, federal government, you screwed up on that interpretation, we're suing you. Take another look at it, we want the courts to look at it. And then lawyers are involved. And people love to curse lawyers and complain about us, but one thing is we're also a check on the system. We're not just there advocating for our clients, that's our prime job, we're to be zealous advocates for our clients, but we're also officers of the court. We have standards we have to comply with. We have a license that's issued from the state of Colorado, and if we counsel our clients to break the law, that is breaking our ethical requirements, and we lose our license. That means we cannot practice law anymore. And you know lawyers would hate to lose that license to practice law. So there are all these checks that make that skepticism of that focus group not well grounded in the world, at least that I live in. So I'd ask you to join with me in that factual foundation that we do have laws and they do matter in the US. Another thing as we walk through these statutes, I can't really talk about the permitting process in all the detail, but as you can imagine, these laws and statutes set up requirements, and you as an applicant have to demonstrate through those piles of paperwork that you are in compliance with the law. That has to be determined ahead of time. So there are a number of studies. There's another group of people besides lawyers that depend on these laws, and that is environmental consultants, people that do archaeology, anthropology, water, air, any number, and then NEPA compliance. So the permitting process is very detailed. And then one theme you'll see running through the presentation is that the law is not static. It changes. It changes with new information, with new pressure points that come through the public or from new events, new activities. So you'll see those changes, and I'll try and call those out. We're going to start first with something I've found in my practice that is a source of a lot of confusion for regulators, much less the public, and that is our federal system of government. We have the federal government, but that's not the only government. We have state government as well, and they share legal responsibility when it comes to regulating the oil and gas industry. So we'll look at federalism. What is that relationship? It's in our Constitution. What's the federal role in oil and gas regulation? And then what is the state role? So if you remember your 8th grade civics class, you remember that we have a constitution of enumerated powers, limited powers. So everything that's not spelled out going to the federal government, that is left to the people or to the states. So that's the important 10th Amendment. When it comes to federal law and oil and gas, there are 2 important provisions in the Constitution. One is the Supremacy Clause, and that makes the statement that federal law prevails over state law when there's a conflict, a direct conflict with federal law. The Property Clause of the Constitution is where the Constitution says who's in charge of public lands. And Congress has the authority to make regulations for federal lands. So those are 2 important clauses that come into play here in Colorado. So you have the states operating and regulating, and you have the federal government. And it is overlapping jurisdiction, which is, I think, where some confusion can come into play. In general, our federal environmental laws set out baseline standards, and they have oversight. But state governments then are given primacy when they prove up that their federal environmental program meets the standard that EPA has laid out. Then they're given formal primacy, which Colorado has, and they then implement the statutes. So you see a very close relationship there between the federal and state government. And then ideally, in the ideal world, the Platonic world of happy thoughts, we have cooperation among state, local, and federal governments. But we live in the real world, and there is, as I said, there can be confusion over who is in charge. Is anybody in charge? It's confusing to sort it out. And then there's always agency turf battles. Agencies want to expand their turf, and so that can add to confusion. This is just a little illustration of some of the key federal agencies that are involved when you permit oil and gas in western states. The BLM, the Forest Service, the EPA, the U.S. Army Corps of Engineers, which is part of the Department of Defense, oddly enough, but is in charge of wetlands, the Advisory Council on Historic Preservation, the U.S. Fish and Wildlife Service. So historically, there wasn't much regulation of fracking. And here I'm using fracking in its narrow technical sense as that stimulation activity that happens downhole. We're living in a time when people use the term fracking to mean all oil and gas. But I'm talking right now about regulation of fracking, and historically there wasn't any. Just on Monday, on St. Patrick's Day, the oil and gas industry celebrated the 67th birthday of the invention, or the first commercial use of fracking. And that was by Halliburton 67 years ago. And so there was not much regulation of that, certainly by the federal government. States, through their oil and gas conservation commissions, were regulating oil and gas development. Now that has entirely changed. Now states and the federal government are getting very active and focusing on the specific technology of fracking, as well as more restrictive laws on oil and gas in general. So we're going to start with the so-called fracking loophole, or as some like to call it, the Halliburton loophole. And this is the Safe Drinking Water Act, our first statute we'll talk about. And it means what it says. It's focused on only certain bodies of water. And those are water bodies that are either drinking water quality now or could be. So this doesn't cover surface water and all groundwater, just certain aquifers that are of drinking water quality. And there's 2 important provisions that I'll talk about when I'm focusing on this oil and gas discussion. And one is the endangerment standard. It's a general standard that requires a program and policies by a state government to protect the quality of drinking water. And then the underground injection control program, also designed to protect underground water quality, but it governs the many different types of injections of substances, of waste that go into underground non-drinking water quality aquifers. There's a lot of waste that's disposed of down below that many of us don't think about, but one that's coming up in the future is carbon sequestration. If you need to sequester carbon, you need a UIC permit, and EPA came up with a brand new class of UIC permits for that activity. Oil and gas activities are governed under Class 2 UIC permits. In most states, those are handled by the Oil and Gas Conservation Commission. So when did this frack issue get started? It got started in 1995, and when EPA, then the Clinton administration, you see Carol Browner pictured there, she was the EPA administrator at the time, they took the position that the Safe Drinking Water Act did not cover frack fluid injections because it was a temporary injection. And again, the UIC really governs waste disposal. So they argued that frack injections were not covered. All right. Problem.
Oh.
Hello.
We're
There we go.
Okay.
Okay, so this environmental group called LEAF, Leaders in Environmental Action for the Future, challenged EPA's perspective in Alabama. And they argued successfully to the 11th Circuit that, hey, just read the language of the Safe Drinking Water Act. It says underground injection. It doesn't say anything about temporary or permanent. And the court agreed and said, you're right, the statute reads that way. Underground frack injection should be covered under the Safe Drinking Water Act. EPA in Alabama didn't like that answer, and they didn't fall into line, and they thought of another way to address the court's order and said, we'll cover fracking under the endangerment provision, so section 1421. So EPA and the state of Alabama did that, and the court said, yes, that passed muster. He deferred to EPA's expertise in that case. It was ambiguous as to what they had done, and EPA has the expertise, so courts defer to it, so they won that case. And then in 2004, the study that had started in the Clinton administration completed in the Bush administration. It was a study of hydraulic fracturing in the context of coal bed methane. And it was determined there was little to no threat to drinking water, but if you use diesel to frack, that was a concern. So in that context, uncertainty had been injected into the settled way of doing things. The Energy Policy Act of 2005 came in with the fracking exemption. So it was, as many things are in the legal world, a reaction to a court decision. Uncertainty was there. How do we fix it? We go to Congress, and we have this statute enacted. So this statute, you can read it for yourself there. It exempted the fracking from the Safe Water Drinking Act, but excluded frack jobs using diesel. Well, EPA never got around to doing any rulemaking on diesel. There's quite a kerfluffle over that in the early days of the Obama administration up on Capitol Hill when the Democrats were still in charge of the House. So more recently, EPA in 2014 just issued guidance on how to use frack fluid in conformance with the Energy Policy Act. The Safe Drinking Water Act also covers the disposal of two types of water. You have produced water, which is water that comes out of the formation with your oil and gas. And then you have flowback water, and that's the water that flows back out of a frack job. And those are regulated by the Safe Drinking Water Act. It requires a UIC permit, certain protections, again, to protect the drinking water. And an important hammer that EPA retains is its imminent and substantial endangerment enforcement authority. Whether or not the states have delegated authority, EPA has that tool to step in. They've done that in several frack cases, but not successfully so far. In other words, they haven't won their cases. All right, now we're moving to the Clean Water Act. Now this is another group of, a different group of water bodies. This is mainly your surface water, and the Clean Water Act prohibits point source discharge of pollutants into the waters of the U.S. In a case that I was involved in before I became assistant secretary and my former partner finished it to conclusion, it was determined, again in the case of coal bed methane water, that if you pumped out unaltered groundwater and then discharged into surface water, that was a violation of the Clean Water Act. You needed a permit to do that because unaltered water associated with industrial practices was pollution under the Clean Water Act. So we don't live in a zero discharge world. We discharge pollution into water bodies, but they're limited by permits and clean water standards, and it's a very complicated area of expertise, the Clean Water Act, but in essence, the permits are meant to make sure that whatever goes into the receiving water will not damage the water quality that's been established for that particular water body, for its uses, in whether it's for aquatic or other uses. So again, in the case of the Safe Drinking Water Act, states also gain primacy and they implement the Clean Water Act. So the permitting process are the issuance of these MPDS discharges if you have a point source discharge. And that's a specific thing. So the other tool that EPA can use to manage discharges from industries are industry-specific effluent limitation guidelines. And that sets a kind of a base standard of how much you treat your discharge so that you will comply with water quality standards. And there are some existing ELGs for oil and gas. You cannot direct discharge produced water into surface water. You have to inject it into non-potable drinking water formations. And in the western US, again, in the coal bed methane context, produced water that was potable and usable for agriculture and wildlife had an ELG to allow it to be done in Wyoming. That was employed quite a bit. Now, a very important ELG that's underway right now is the shale flowback pretreatment standards. And so shale gas is what we're all talking about, shale gas and shale oil. And that has created a huge volume of water coming out. That has overwhelmed treatment plants in Pennsylvania in particular. EPA sees this problem. They say we better do an ELG to address it. And so we're going to see a draft ELG out in the spring and then a final in December 2015. So this is an example of the law changing in response to a new activity and a problem. So here's some other provisions in the Clean Water Act, just quickly. This is another exemption that is often highlighted. In 1987, oil and gas, most of oil and gas activities were exempted from compliance with stormwater. Now, stormwater is not point source pollution. It's non-point source. And stormwater is the water that flows off the parking lot on campus. The water that flows down streets or overflows in storm events, that's stormwater. And there are permits that have to be obtained for that. The Energy Policy Act in 2005 expanded the existing exemption for oil and gas to include construction sites. But by and large, states with oil and gas are regulated by the state for stormwater regulation. They have to obtain state permits to regulate stormwater discharges. The next statute, SPIC, it's about preventing and reporting spills near water bodies. This is implemented by EPA. And then again, the final very large statute, it's just on this page with two others, but it's a huge compliance activity, and that is wetlands. What is a wetland? It's more of an art than a science. There's many people employed figuring that out. What is water of the US? There's just a big case that was in the paper today about a Wyoming guy who got in trouble with that. So you have to go through a permitting process with the U.S. Army Corps of Engineers. You have to mitigate impacts. EPA has a very strong veto authority. That's much in the news in the context of coal mining back in the East, where EPA vetoed activities that the Corps had approved. So that's a big statute for oil and gas. All right, we're leaving water. We're not going into the air. This is another very regulatory statute, and it regulates our emissions from our cars and trucks and the vehicles that use in oil and gas sites, and then stationary sources, which are your power plants and factories. Again, EPA sets standards, these national ambient air quality standards, and in this case, the states then develop a plan. What is their state implementation plan to control air emissions so they can meet these requirements? And there are 6 criteria air pollutants. You might know that Denver is in non-attainment on the Front Range for ozone, and so that's what that means. Colorado SIP is not meeting the statutory standards that have been set out. So that is what the state has to do to ratchet down to meet those standards. EPA also regulates hazardous air pollutants, and in a newer provision requires the reporting of greenhouse gases. So a couple rules that were passed or put in place by EPA recently that impact the oil and gas industry is the 2008 EPA oil and gas diesel engine rule. It reduced NOx by 97% and particulates by 90%. This is just air pollution and impacts visibility. And then a very significant rule that was made effective October of 2012, and it's a mouthful, but it's the New Source Performance Standards, National Emission Standards for Hazardous Air Pollutants, NSPS NESHAP is its acronym. So it does a variety of things, but the key thing it does is tackle the formation of VOCs. And VOCs plus sunlight equal ozone. And ozone is what Colorado's in trouble for. You have ozone problems in Utah in the winter, ozone problems in Wyoming in winter associated with oil and gas development there. Very puzzling. Nobody thought ozone would form in the winter, and they've been studying that for the last couple of years. But what this new regulation requires are certain standards for oil and gas companies to comply with so that they reduce leaks of VOCs, green completions, controls on plants and facilities. So I want to talk a little bit here right now about methane. One of the things that you hear a lot is that, well, all this natural gas isn't really that great because methane is a very strong greenhouse gas, 20 times more potent than CO2. And if you look at how much methane leaks during oil and gas production and transportation, then it cancels out the admitted benefit of natural gas emitting 50% lower CO2 than coal. So natural gas is not as great as it's talked about because of methane. So methane is much in the news, and very confusingly for those of us following it, there's been a number of different studies. Each of these studies are not apples to apples, they're more apples to oranges, but there's a lot of different information. EPA keeps an inventory. They had one number, then the University of Texas, working with industries, and EDF studied actual emissions from actual sites. They came up with, no, EPA, you're 97% out of whack. EPA said, yeah, we were looking at things before all these new controls came on, and you have a point. Then a recent National Academy Science study took a whole different look. They looked at, okay, what's out there in the atmosphere? Instead of looking what's being discharged, they're looking, where's this methane coming from? And that said, well, wait a second, it's 50% higher than EPA said. So all very confusing. There's a lot of studies going on, but an important change that was put into place in February by EPA is a requirement that the oil and gas industry now will have to be more precise in reporting its methane discharges. So the good news on that 212 VOC rule I told you about is that it will have a side benefit of cutting methane by 25%. So when those best practices are put in place, those requirements, methane will be controlled by 25%. Good news in the state of Colorado is that they have taken a leadership role in advance of the federal government and in advance of any other state, and they have passed the first rule to directly regulate the emissions of methane. Methane is not one of the criteria pollutants that I mentioned earlier, one of the 6 criteria pollutants. It's not on that list. So Colorado has regulated it, and And that just happened last month. So the feds are not going to be too far behind on that. BLM issues onshore orders. They are regulations that go out from notice and comment public rulemaking. And we're expecting an onshore order number 9 to be coming out that will update an existing order and address methane emissions in August of 2014. Department of Energy Secretary Moniz was talking again today about the fact that EPA and the White House and DOE are looking at control of methane. And then the important thing to know is that 2012 rulemaking was focused on natural gas. And a recent study that just came out said, wait a second, oil is going to be producing a lot of methane as well. There'll be a lot of methane escaping in oil production. We have a lot of oil being produced now because it's more valuable than natural gas. That's what's going on in North Dakota, in the Eagle Ford, in Texas. So question, will EPA then take a look at regulating oil and methane discharges there? So we're leaving the air and we're going to waste. So there's 2 federal statutes that cover waste, one called RCRA, the other CERCLA. CERCLA is better known as the Superfund statute. RCRA covers cradle to grave is how it's referred to. You basically track waste from when it's generated to when it's disposed of. And that was to address the problem of people generating waste and then just dumping it beside the road, leaving drums around, etc. So that was the purpose of this statute. When it was, some years after it had been put in place in 1980, there was an amendment made to the statute that excluded oil and gas, drilling fluids, produced water, and other E&P waste. Congress determined that those were not RCRA subtitle C hazardous waste. And they directed EPA to study this. Is this correct or are we wrong? And in 1988, EPA came back and said, no, there's adequate state and federal regulation of this type of oil and gas waste. It's not appropriately regulated under subsection C, so don't worry about it, Congress. So then in 2002, they came back and amended it and said, if you have unused frac fluids, they could be subject if what's in those unused frac fluids are hazardous, or otherwise listed as hazardous. And all these things, hazardous, that isn't just somebody's back of the envelope guess. There's listed, identified hazardous substances that are compared. So one of the new things that is underway is a petition by the National Resource Defense Council, NRDC. They petitioned EPA, which is a provision in law. You can petition EPA to change their regulation. And so they asked EPA to reconsider their 1988 study and the exemption and whether or not it was still viable in 2014. So EPA, that's under EPA review as far as I could tell. I had not seen an EPA response to that. In general, this E&P waste, as EPA found in 1988, it's managed by the states. Superfund is directed at specific sites. Most of the time it's places where there's waste left there, hazardous waste, nobody's around to clean it up, and that statute focuses on those kinds of sites. Again, petroleum substances are not defined as hazardous, and again, EPA has clarified that if a petroleum substance has hazardous substances in it, then it would be subject to CERCLA. But in general, petroleum is exempted from Superfund. So one of the important studies that is underway is one that was directed by Congress. So Congress can get in the act to change the law. They don't necessarily just change it right off the bat. Here they're directing EPA and say, EPA, study the impact of fracking on drinking water. And EPA came up with an approach. This was back in 2009. And they're looking at these 4 topics. The withdrawal of water, there's concern about that, the amount of water that's being withdrawn, the discharge of frac fluid, the handling of flowback, frac injections, what happens with that? Does it threaten drinking water with the fractures? And then how do you dispose of and treat frac fluid waste? This is a stakeholder and peer-reviewed process, so the public gets to have input. There's other scientists involved in it. They're doing all kinds of research projects. In December of 2012, they issued interim status on these research projects. You can go to EPA's website and look at that report. It's fairly detailed, but it does not come to any conclusions at this point. The completed study is expected in late 2014. I would be surprised if it was issued in late 2014, just because everything the government says it will do most likely doesn't get done by the date they want it to, but that's when they're targeting. So another action that's going on at EPA that was just announced in February 2014 is EPA's Inspector General. Now, every agency has an Inspector General. They're a watchdog. They're primarily an arm of Congress. They're meant to prevent waste, fraud, and abuse. So he's not part of EPA, although he's in EPA. And the Inspector General said that they are going to take a look at what is the authority that EPA and states have to regulate fracking water impacts. So I'm not sure where his study picks up and EPA's ends, but this is a separate study that was just announced. These are two other statutes that are important to local communities. The first one, the Emergency Planning and Community Right to Know Act. This requires that individuals and communities have access to information when there's a release of hazardous chemicals. Oil and gas have to give release notification when there's a spill on an oil and gas site. They have to notify both state and local government. They're storing hazardous inventory that has to be also reported. The exemption that they have is from the toxic release inventory reporting. It's a list of toxic release. And in this case, again, we have another petition to EPA that is petitioning EPA to require oil and gas to maintain a toxic release inventory reporting system. And again, I have not seen a response to EPA to that, so it's probably still under consideration. TSCA is the regulation of toxic chemicals, and this is another responsibility of EPA. And these toxic chemicals can be everything from pesticide to herbicide to frac fluids. Here, Earth Justice made a petition in 2011. They said oil and gas frac fluids need to be subject to TSCA testing and reporting rules. And in 2013, EPA said no, they're not going to test under the TSCA provision number 4, but they did say that there should be data gathering. They're not going to require individual applicants, oil and gas producers, to do the data gathering. They're going to do it more in the aggregate. They thought that was more appropriate for this industry. So that was sort of the once over quickly on the federal environmental laws. And this is a report from the U.S. General Accounting Office. Again, this is an agency that responds to Congress. They investigate things that Congress requests. This was a request Congress made in 2012. What authority does EPA have to regulate fracking? What do states do? And this chart simply illustrates that where EPA or there's a federal exemption, most of the states that are covered, the 6 prime oil and gas states, have state laws to fill that gap. So the chart is hard to read, but you can read it if you have the handheld PowerPoint, but highlighted some of the key provisions that we've already talked about as exemptions. This is a little summary for Colorado. When you talk about the safe drinking water frac exemption, there's Colorado, a lot of extensive Colorado regulation of oil and gas. These are just some of the rules that COGCC has. Of course, Colorado requires disclosure of fracking fluids. They have casing, cementing requirements. They govern solid waste for oil and gas. They regulate emissions of methane, and they have a stormwater permitting statute in the state of Colorado. And you could go to Wyoming and Texas and other states and see a similar list, but obviously not with the methane rule. All right, quickly now we're just going to talk about oil and gas development on federal lands. We have federal lands, obviously, in the state of Colorado, Forest Service and BLM lands. The Supreme Court has found that the federal government has an extensive scheme of oil and gas regulation. We haven't talked about that yet. That was all the environmental laws that apply to oil and gas, but there are also then regulations under the Mineral Leasing Act of 1920 that apply to the development of federal minerals. BLM manages all federal minerals that are onshore. So whether the federal mineral is under BLM, under the Bureau of Reclamation, under the Forest Service, under private fee service, BLM manages those federal minerals. Now, a lot of comments have been made by the governor and others kind of bemoaning the state of affairs with split estates. That goes back to Western history, the Stock Raising Homestead Act of 1914, 100-year anniversary, 16, there was another one from 14 too. So anyway, coming right up on this important anniversary. But initially when the government invited people to come out and homestead, they said, yeah, take it all, surface and minerals. Then there became to be some abuses with coal mining and different statutes where the government was supposed to identify lands that were valuable for coal and not give them the minerals to the homesteader. Well, there was some fraud and abuse going on there. So Congress changed the statute and only conveyed the surface in the mid-1900s to homesteaders. And the Supreme Court has found in this quote here the reason why they retained the minerals. They felt the federal government should retain the federal minerals so they could manage them for the benefit of the country. They didn't want, quote, farmers and ranchers making decisions about federal minerals because that was a valuable foundation of our country, the federal mineral ownership, especially at that time. So we again have a cooperative relationship between BLM and the states. There's actually an agreement. All public land states have a specific agreement with the BLM on how they manage oil and gas. Basically, you can look at the state of Colorado manages downhole oil and gas activities, and the federal government manages surface impacts to surface lands. That's their prime concern as a land management agency. BLM is getting into the frack regulation game. It's been struggling to do so for several years. I think since, 2011, BLM was supposed to issue an updated regulation of fracking. And there's been a lot of drafts and pushback and drafts and pushback. Still hasn't come out. I put it will be issued in 2014, but I don't know if it will or not. But they keep saying it will, so we'll see. So BLM manages federal lands under the Federal Land Policy and Management Act, FLPMA. It's a multiple use statute. And as the Supreme Court has said, that sounds really simple, multiple use, but it is a very complicated task of balancing many different uses because our lands under FLPMA are valuable not just for minerals, but for recreation, for fiber, for trees, for wilderness, for wildlife habitat. There's a lot of different values that BLM is supposed to be managing the land for. And not all land has to support all uses. That would be impossible. But you have to balance these uses, and it's not easy. So one of the important tools in the oil and gas arena is the Resource Management Plan. And BLM has about 51 land use plans. So they're not state-specific plans, but they're certain planning areas, and you have a field office in charge of that planning area, and so you have a resource management plan for that area. These plans have to go through NEPA, public comment, and they're developed. They usually are long-lasting for 10, 15 years. They are amended as time goes by. But these land use management plans, they have to comply obviously with all environmental laws. They have to coordinate with state and local land use plans so long as they don't conflict with federal management of its own surface. But the important thing for oil and gas is that they identify in the plan what areas are open to oil and gas, what areas are closed, and then what areas are open to oil and gas but with special stipulations to protect these other resources. So you see the standard lease stipulation there. Again, minimize impacts to these other resources. But then there's 1,000 different categories of other stipulations that are added through the resource management plan and attached to the lease, which is a property document between the government and the lessee. So it's a binding legal document. And these stipulations limit what can go on that surface. They may say no surface occupancy. So you can access the minerals, but you cannot do it from this particular piece of land. Or they may say you must protect elk calving grounds. So you can't go in between X date and Y date. And there are many of these. And sometimes you get down to a window of 4 to 6 weeks when you can access that mineral estate because of all these various restrictions. So again, it's a very important provision, and it comes about through a public process, land use planning. Secretary Salazar put in place 2 other process layers in 2010, lease sale NEPA. I talked about resource management plan NEPA. That used to be sufficient to lease oil and gas. You would rely on that NEPA and say there was no more NEPA to do. Secretary Salazar said, no, now before a lease sale, you're going to do a parcel-specific lease NEPA. So he put in place a comment process. So now when lease parcels are noticed for sale, the public can first comment and say, hey, what about this, that, or resource that I value on that land. And then also, once the parcels are identified for the sale, they go through a NEPA process, which again is another public comment process. So that's a new layer of NEPA. And then master leasing plans, these are certain identified layers which are going to get another drill down planning NEPA process on them. Colorado has some, Wyoming has some, and Utah. Utah is the one that's moving forward the first. U.S. Forest Service, they are what is called a consenting agency. The Forest Service also has multiple use, but they don't manage the minerals under their surface. They manage the surface. But before BLM can lease minerals under Forest Service surface, they need to have the consent of the Forest Service. The Forest Service doesn't consent, BLM cannot lease that. I have a client right now back in the east. They're trying to access minerals under a U.S. Army Corps of Engineers dam facility. And the Bureau of Reclamation is the consenting authority. And if they say no, we can't lease. We're trying to change their mind. So, all right, so the Forest Service works together with BLM in developing the federal minerals. If they do consent to leasing, then they must issue a surface use plan of operations. This again restricts how the oil and gas is developed to protect the Forest Service resources on the surface. All right, now a very big important tool in the federal arena is the National Environmental Policy Act. It doesn't tell you what to do or how to do anything. It's a disclosure statute. So it's, in the world that I operate in, it's a stop, look, and listen statute. You take a hard look at, the federal agency has this duty, not the applicant. The federal agency has to look at what are the environmental impacts from this federal activity I'm authorizing. I'm going to lease this land, or I'm going to give this guy an APD. What are the impacts? Disclose them in a NEPA document. So we had the resource management plan NEPA, then we have the leasing NEPA, and then if you have an APD, an application for permit to drill, that is, you want to drill a well, you have to do another layer of NEPA, and then say that well proves out, and you say, oh, I can do about 15 wells. Then you may do a plan of development, and that would require another layer of NEPA. And each of these layers of NEPA, by and large, have comment processes. Comments are only required in the most stringent analysis, which is the environmental impact statement. That's where the agency has said there are going to be significant impacts. It discloses them. But even in environmental assessments now, both BLM and Forest Service routinely provide comments for environmental assessments, which are not required by statute. And again, there's a role there for state and local agencies. They can become cooperating agencies. And this was something I actually pushed really, really hard when I was assistant secretary. And BLM put in place a rule, a regulation, that directs their managers to ask state and local governments to be cooperating agencies, and it allow them in. Before, the federal agency could say, no, I don't want them in. and I wanted to make sure they were in, because I think the views of state and local people on BLM's land use planning are very important. So every EIS that BLM does and every EIS that the Department of Interior does requires the opportunity for state and local governments to be involved. Now, they all can't be involved. It can be costly, but there's that opportunity, and I think it's an important one. So then, last two things that are key that BLM has to comply with and Forest Service are wildlife and historic and cultural resources. So we have the Endangered Species Act. Again, any federal action triggers the Endangered Species Act, and the federal agency has to go through what's called the Section 7 process and has to analyze what are the impacts from the activity on threatened and endangered species, and moreover, not just threatened and endangered. I have a client right now that is being held up because they are having impacts on the hookless desert cactus, which is a species that's proposed for listing, and that is going through the Section 7 process. So a wider purview than you might think, not just what are listed. One of the key things that's happening in Colorado is the sage-grouse resource management plan amendments. This is happening in 12 different states. It is going to have an enormous impact. I was talking to somebody in the BLM just yesterday, and he said basically with the provisions that BLM has recommended in its resource management plan, Northwest Colorado will be basically shut down from oil and gas development. There are 4-mile circles around lakes, and that amounts to 50 square miles, and you start placing those over the landscape, it becomes pretty difficult to do much of anything. Well, that process is moving towards a completion in, I want to say, 2015. That's when Fish and Wildlife Service will decide whether or not to list the sage grouse. And nonetheless, these BLM RMPs will change these stipulations I talked about and generally make them more onerous in sage grouse habitat, more restrictive. Migratory Bird Treaty Act, Bald and Golden Eagle Protection Act, very important statutes. The renewable energy industry is tangling with these. It's causing quite a slowdown and concern among renewable energy developers, but oil and gas developers also have to be concerned about impacts to these birds. And Migratory Bird Treaty Act covers every single bird except the starling, just about. The starling is viewed as a nuisance bird, but every other bird, crow, blue jay, you cannot harm or harass these birds. So again, very extensive jurisdiction. Again, Fish and Wildlife Service work cooperatively. BLM manages the habitat, but the state Game and Fish manages the wildlife, the hunting seasons that we have in Colorado, other management that they do. So again, there's a relationship there. BLM relies on the state to provide it information on wildlife data for their resource management planning. Historic and cultural resources, this can be anything from old mining cabins to more frequently Native American cultural and religious artifacts, sites that are sacred to Native Americans. And there's another process quite similar to NEPA, the National Historic Preservation Act. Again, it's a process statute. Stop, look, and listen. What kind of impacts are you having on historical cultural resources? It requires surveys. Again, these are the people that go out and survey the ground. Look, what are the artifacts there? And then there's several other statutes that I listed that are very direct at protecting human remains of Native Americans and religious sites that are important. So local government, their roles for local government I talked about. This is just a quote from a Supreme Court law. When state or local law comes into conflict with the objectives of Congress, then that state and local law goes too far. I heard a proponent of the initiative that's out there that would change the Colorado Constitution to prohibit certain things regarding fracking, and the person made the comment, well, you know, that would take precedence over the U.S. Constitution. No, go back to the Supremacy Clause. That would not happen. So, anyway. All right, so that ends my lawyer presentation. I will put on my policy hat now and talk about why I think fracking, or I think it's more accurate to say oil and gas production in this country is a good thing, and we're lucky to have it. When I was assistant secretary in the early 2000s, we could not produce enough natural gas to supply the heating and electrical demands that the Clean Air Act had driven power companies towards. And we were running out of gas. We were running hard to stay in place. When I was leaving Washington in 2005, one of the last meetings I went to was a big dog and pony show that Exxon put on. And they were talking up the fact that we had to import natural gas into the US. That was the only way we could make it. Well, now that's totally changed. Beginning in 2007, we now have abundant supplies of oil and natural gas in the US, something nobody thought was possible. So what's at stake with these fracking bans, which are really oil and gas bans? Most of our modern oil and gas is produced using fracking. So when they say fracking ban, translate oil and gas ban. So obviously you have to have good regulation in place, or you're not going to have the consent of the people to this development. So this is pointed out by the International Energy Agency. If we don't get the regulation right, the people won't support it. They'll have concerns, they won't support it. Natural gas has led to an economic revival in our country, as has oil. Steel is being produced in the US again, something nobody thought would ever happen because natural gas is cheap. President Obama in his 2012 State of the Union pointed out the jobs that come from natural gas and statistics from other agencies in the federal government, domestic job growth, and $120 billion impact to the economy. And in a weak economy like we still have, that is important to many people. Fracking, oil and gas development also helps our US energy security. Now, when I was in office, the statistic was we were importing 60% of our oil. That has now changed dramatically. And importing all that oil, although a lot of it came from friendly countries like Canada and Mexico, a lot of it came from countries that didn't like us, like Venezuela and Middle Eastern countries. That put us in their grip a bit. Also, it made our balance of trade payments upside down because we were importing all this oil. But now, for a few years, we're going to produce more oil than Saudi Arabia. Once had an economist from a major oil and gas company tell me, when he tried to explain to me how much oil Saudi Arabia has, he says, when the last drop of oil is used, it will be Saudi oil. They just have an enormous supply, but we are exceeding them now. And then geopolitical. This is in the news right now. Russia has natural gas supply, goes through Crimea and Ukraine to Eastern Europe. They've already used the natural gas card to freeze elderly people in Europe. And they have been threatening, raising pressure on Kiev, the capital of Ukraine, with gas threat. I like this quote I found: Putin is the dealer, Germany is the junkie. They're very dependent. I think Germany is 40% dependent on Russian gas. Other countries in Europe are 80%. These are the headlines with papers from all sides of the political spectrum, from the New York Times, Wall Street Journal, to the Washington Post, and the Financial Times, calling on the US to use that card. And what is that card? Let's export natural gas to Europe and change the leverage that Putin has over Europe. So, very important, what fracking has brought us. We could not have done that in 2001, 2002. We didn't have enough natural gas to meet our own needs, and companies were leaving this nation to go overseas. And then another important fact is the clean aspect of natural gas. We are the only country in the whole world, no matter we didn't sign Kyoto, that has seen carbon intensity drop. We're now down to levels in 1994. So here's a quote again from International Energy Agency: dropped off 5 million tons in 5 years, more than any other country examined. So President Obama's latest State of the Union, he talked about natural gas. He called it a bridge fuel for our economy with less of a carbon pollution that causes carbon change. And then he pledged that he would keep working with the industry to sustain production and job growth, but strengthen the protection of our air, water, and our communities. So in conclusion, I want to end with 2 big points. I hope my presentation has illustrated that the oil and gas exemptions from major federal environmental laws are kind of less than advertised. They are exempt from portions of federal environmental law, but in most cases, if not all, states address those exemptions through state regulation. And the other fact is that regulation of oil and gas is becoming more stringent, not less. I've told you about a number of different new rules that have come in place, studies that are being done, so it's becoming more protective, not less. And then I think we need to look at the president's words here. He sets out a balancing act. He wants to sustain production and jobs, but strengthen regulation. So that's the question. How clean do we go? How much regulation do we put in place? When does that regulation become uneconomic so that we lose the production of this domestic oil and gas? So what are the benefits, the trade-offs, the health, the environmental? Are we going to go for that last inch of environmental protection, but then lose the production of natural gas from one or more basins because it's simply uneconomic to do? So that's where the tough part comes in. Banning fracking is easy, isn't it? Oh, let's just ban it. Well, I hope you see in my policy hat conclusions that we would be giving up a lot as a country if we banned oil and gas through hydraulic fracturing. So I have this slide that will be available on the podcast, and I studied to be a librarian. I have a master's in library science, so I like bibliographies. So I put here some websites that come from the government, universities, Patty's site, industry, and NGOs that provide access to information on fracking. And so I think that's useful. And I am ready for the questions. Thank you.
Thank you. Well, we have quite a range of topics, and I have them clumped a little bit, but not thoroughly clumped, but we'll just jump right in here. A couple of people have raised the same question. Even if the laws are tough enough, without more inspectors, Colorado has just 17, with the other person mentions 50,000 wells. Without more inspectors, aren't we trusting companies to self-report? So is it, yeah, so let's just go with that. Do we have enough inspectors, so even if we have regulations, can we have those acted on?
I remember a couple years ago in 2009 that when that law was passed, and Jim might be able to back me up, or Ken, but they added more budget for more inspectors. So again, if we live in the ideal world, we'd have more inspectors for both the federal and state government, but we don't. We live in a world of government supported by tax dollars. Citizens don't want to be taxed, but I would say in Colorado's defense that they actually passed a budget to increase the number of enforcement. And self-reporting is not to be sneered at. Again, these are pieces of paper that you are legally obligated to sign. If you falsify those reports, you can get into trouble. And again, we have watchdogs out there, environmental groups, communities. So there are a lot of other avenues besides just inspectors, and so that's what I would say.
Okay, sticking with matters of enforcement, are the new methane laws for Colorado self-regulating by oil and gas under existing, well, so I guess, to what degree do the new methane laws for Colorado operate by self-regulating procedures?
I don't think that's self-regulating because, again, you're required to put in place certain types of equipment, and so I would not say that that would be self-regulating, but I can't say I'm a total student of this new law that was just put in place in February. So,
are existing wells, the 50,000 or so, grandfathered in with these new laws, or will these wells be subject to these new rules?
Jim, do you know the answer to that?
They're all subject to it.
That's what I thought.
What was the answer?
They're all subject to it, so it didn't apply just to new wells, but also to old wells.
In regulation enforcement, what if small fines prove to be easier to pay than cleanup or precautions beforehand? So what should there be in the way of penalties that would carry real meaning if you could actually
Yeah,
just
well,
pay them.
I know that that's a cause in the legislature to increase penalties. And again, I think it's more than just money. I think you have reputation, companies have shareholders. Getting violations is not something companies want to have, most companies. And I think penalties are one tool, but there's other pressure, public pressure and societal pressure to do the right thing. And again, I think that no lawyer is going to counsel an oil and gas company to violate the law because the penalty is too low. It's not like the healthcare law where you just pay the fine and you're okay. There's a lot more serious repercussions.
Okay, a couple on renewable relations or ties to renewable energy. What benefits named by fracking will not occur if any renewable energy production is stimulated instead? So this, we'll just cast that as the, how does that play off together, those two forms?
Well, I do a lot of work for solar companies and wind companies, so I'm ecumenical when it comes to energy. My belief is that we need all the energy we can get. IEA says that world demand for energy is going to increase by 40% over the next 15 years. Right now, renewable energy supplies, all forms of renewable energy, are under 10%, and wind and solar are around 3%. And that's in the US. In the world, wind and solar are under 1%. So how do you scale up renewables in any kind of realistic time frame to meet the demands of our very technology-dependent society? Many of us order from Amazon, from Zappos. Those big server farms that support those companies take up huge electricity demand. They're enormous to both run the system and cool it and heat it. So we use a lot of energy here, and you can't put solar panels on top of a server farm and meet the demands of that kind of a high-tech business. So I think that solar panels on homes, that's important. You can have the white roofs program that California has, but that's not going to meet the total demand for energy. I think fracking is critical. If we got rid of oil and gas, what would come to take its place? I can tell you my wind and solar clients can't gear up to do that. When I met with the wind energy when I was assistant secretary, they said their goal over the long term, in the immediate long term, was to get to 6% of US energy supply. That's what they thought they could do technologically. And I think it's important that we support wind and solar, because it's only by putting that technology out there that we can learn by doing, that we can make wind turbines more efficient, that we can make solar more efficient. And I think that's important. The other thing, going to wind and solar, where's the transmission? I think if you talk to Steve Black, Secretary Salazar's former counselor, he learned at Interior how hard it is to site a transmission line, a new transmission line to support wind and solar, which frequently is not located near transmission lines. So it's not a simple thing, but it's something I think we need to move towards. The good news, as I said, is that natural gas has reduced our carbon emissions, and natural gas can back up wind and solar and support those industries.
Does the renewable energy industry face similar challenges in permitting development projects? Do the laws need to be reformed to promote renewable energy projects?
Yes, I would say that that was one of the most interesting experiences I had after I left the government and started working for a concentrated solar power company. Their view was, well, wait a second, we're green energy, we're good. What do you mean these laws, the Endangered Species Act and desert tortoises, we're putting a solar power plant here. And so, yeah, there was a little bit of a disconnect among wind and solar companies to understand that when they're going to use public land, which was very attractive to them because it's wide open, there's no development on it, and they thought they could get it cheap. Everybody always thinks they can get federal land cheap. So that these laws do apply. I would say that one of the things that Congress is taking a look at, they are concerned there's been uneven application of the Migratory Bird Treaty Act and the Bald and Golden Eagle Protection Act. They're having a hearing on that on Tuesday. And they've been hounding Fish and Wildlife Service Director Dan Ash to submit documents. They've issued a subpoena against him because there has only been one prosecution of a wind farm for killing eagles. and that was just in Wyoming at the beginning of this year. So I think some would say there's been uneven enforcement. Oil and gas mining companies have been enforced under the Migratory Bird Treaty Act. When birds go into their holding ponds and drown, they have to take measures to keep birds out of there. So yeah, and whether or not these laws to be changed, I think that's a really big question that's hard to answer. There's a lot of laws that ideally would be nice to change. Why do we have BLM in the Forest Service? Why don't we have them both in an interior? There'd be a lot of common sense things we'd like to do if we were king for a day or queen for a day, but not going to happen anytime soon.
Well, in this case, the follow-up question for the one I was just doing is oil and gas given special treatment in permitting that gives an advantage over renewables?
I would not say that was the case, no. Despite what Secretary Babbitt said in Boulder last night, I don't think that oil and gas gets special treatment. I think if you talk to rank and file BLM officials like I do, they find that it is difficult to get support to develop oil and gas. I think the statistics demonstrate that in this administration, while natural gas and oil production has shot up on private lands, natural gas is going down on public land, and oil production is going slightly up on public land, but not to the extent it did in private land. And I would say that for my oil and gas clients, it's very difficult to navigate this system. I could tell you many stories of clients that I have right now with the difficulties that they have, the opposition that is facing them, and there's not much special treatment that I see. So I don't, and I would just say that I don't think that's a fair comment on BLM career officials. I think that they have integrity and they try and, yes, they do. So that's what I would say. You rolled your eyes.
Last night, speaking of Bruce Babbitt, last night Bruce Babbitt suggested the BLM is allowing oil and gas development in sage-grouse territory. Can you further explain your comment that Northwest Colorado will likely be heavily regulated for sage-grouse protection?
What I think that, what I read, what Secretary Babbitt said is that he pointed to a document that was prepared in Washington, D.C. called the NTT, and it was a group of scientists that looked at literature and came up with some interim proposals while BLM conducted it. I thought his comment was kind of strange because he said the Washington, D.C. BLM came up with this report, but then they've allowed the BLM land managers to do RMP planning. Well, that's the way RMP planning is done. Land use planning is done in the state, in the district where the land use plan is. It is not done out of Washington, D.C. So that comment I thought was incorrect. I would say that BLM is being criticized for relying too much on the report that Secretary Babbitt favors. And they've been criticized, in fact, by Governor Hickenlooper and our own state game and fish agency that the report is wrong and decisions made on the base of that will be incorrect for Colorado, and that you need to look at things like topography and other things to do that. So,
okay. A couple of sort of more detailed and technical things. Can methane be extracted from coal on an economic basis? For economic basis?
That's an interesting question. I think technically that methane can be extracted from coal. Methane is dangerous to coal miners. I mean, that's when you have explosions in mine, it's methane. That's what the canary was going in the coal mine to alert you to, was methane. So methane is not a friend of coal. I would say in Wyoming there were conflicts between coal bed methane developers and coal miners. Coal miners were concerned as oil and gas development would conflict with their eventual mining. So there was conflicts there, and there still are, I can tell you that. And then I think in Colorado there was a statute passed about coal mine venting of methane and some kind of provision for that, or they were trying to get one passed, but I didn't keep track of that. So.
Okay. The current issue of the Boulder Weekly discusses oil and gas's exemption from E&P waste under Subtitle C of the Resource Conservation and Recovery Act. Since so much E&P waste is radioactive, is this an imminent threat?
Well, I think that I talked about that in my presentation, and EPA now is going back to look and decide if this 1988 conclusion and their conclusion in 2002 is correct, that this E&P waste is not hazardous and is regulated by the states under solid waste, non-hazardous. So I'm not sure that all fracking waste is radioactive. I think that's an overstatement. Perhaps in some areas it is, but not all.
What is the difference between an EA and an EAS, or an EIS?
So the way that NEPA works, again, it's a disclosure statute, and you have three ways you can comply with the National Environmental Policy Act. The first is a categorical exclusion. That's where you've done an EA or EIS many times on an activity, like a timber harvest under 10 acres, and every time you've done that analysis, it comes back no significant impact. So the Council of Environmental Quality, who is the regulatory authority over NEPA, encourages agencies to create categorical exclusions so that they don't go through the NEPA process for things that we already know the answer, it's going to be no significant impact. So that's the first tool, categorical exclusion. And then an environmental assessment. That's when you ask the question, is there a significant impact? If there's no significant impact, then you have a finding of no significant impact. So an EA nowadays is a miniature EIS. In the regulations, they call for EAs to be 15 pages and EISs to be 300 pages. Well, we have EISs that are thousands of pages routinely, and most EAs pass 15 after the table of contents. So that is a process. So if you do an EA, and you find there is a significant impact, then you either mitigate it, you modify it, so you reduce that significant impact so you can still get to a finding of no significant impact. But if you can't, then you must go to environmental impact statement. I have an oil and gas client. They were going to do an EA for a project. Air emissions became a concern because of the West Slope. Based on comments and scoping for the EA, the agency said, no, we're going to do an EIS. So they had to start over again with an EIS, which is a longer process, more detailed, more opportunity for public comment, and the governor has an opportunity to weigh in on EISs.
Okay. EPA reversed its position on pavilion endemic contamination. What's going on there?
I read about this just as a scholar, so that is what I referenced in passing, that they have used different authority under CERCLA and under the Safe Drinking Water Act to investigate these alleged incidents of frack pollution. They did not succeed in having a case that they prevailed in. And Dimrock is in Pennsylvania, and Pavilion is in Wyoming. So that's what I can tell you about that.
Okay, a couple on exports. With the current political crisis with Russia, can the U.S., Canada, and Mexico meet EU natural gas needs in the future?
I think the industry would say yes. President Obama in 2012 stated that we have enough natural gas for 100 years. There's a huge supply of natural gas. I think that's the Department of Energy's role, is to analyze LNG exports. They have to issue the license to export liquefied natural gas along with FERC. And I think that we could play a role in Europe. And we could also play a role for Japan. Japan has lost its nuclear capacity. It's turned its back on nuclear energy. It is struggling to meet the energy needs of its citizens, and that's a role, and that's why you see LNG terminals proposed for the West Coast. So there is need for natural gas. The question is, how long will that need exist? Other countries have shale gas, Australia being one of them. They would be eminently suited to meet the needs of China and Japan if they can get their program going. There's also shale gas in Europe, but countries in Europe have banned fracking so far. Maybe when they go through a winter with Russia putting the twist on them, they might take back and reconsider that situation. But right now there's an opportunity for the U.S. to play a role in energy supply.
Experts report that the United States does not have enough gas to export and make a dent in the amount of natural gas Russia produces.
Well, I don't think that's correct. I don't know who those experts are. But if you can provide an alternative supply to Europe that would counteract what Russia is doing, and also Poland is one country that is not opposed to fracking and has shale gas, and they're looking at developing their shale gas. So you could put together supplies that would address EU's demand for energy in the winter season. Germany is playing tough right now because they're headed into spring and summer, and Angela Merkel has commented on that fact, that we're now in a good time point to push back against Russia because we're not in our winter.
This is me. My question here. Could you, just for a moment, connect these geopolitical global issues with an affected neighborhood along the Front Range, and how those two frameworks might be put in some relationship to each other?
Well, I think that's the hard question, because you have, I think, as the governor has tried to point out, two property interests at stake. And when lawyers talk about property, we talk about a bundle of sticks. So it's not just the dirt. There's a lot of different rights that people have when they have property. And one of those important rights that we have in our home is the right to quiet enjoyment of our property, the right to exclude others. But the mineral property right, the only way it can be realized is with access through the surface. Minerals where surface access is prohibited are not worth anything. You can't develop them. So that is why common law and federal law and state law provide for the access right of mineral owners through the surface. So how we address the conflicts and the development of oil and gas to meet geopolitical needs and address the concerns of neighborhoods, I think that's a tough call. And I think it requires a lot of different things. I mean, there can be regulation, there can be communities working with oil and gas companies to ease the demands on them, but at some point there will be conflicts between your quiet enjoyment of the surface and the mineral owner's right to access their minerals. And that's hard. There's no easy answer to that.
Well, speaking of tough communications and diplomatic undertakings, a hit and run occurs when a person hits a car and doesn't report it. What incentives are there to prevent this from happening in oil and gas fields? Not hit and run accidents, but people doing injury and not reporting it.
Well, again, I think that what I laid out here, this regulatory requirements, you don't have oil and gas pirates sneaking around and drilling wells. These wells cost $10 to $15 million to drill, and or more. And in order to drill those wells, you have to raise capital. And in order to get the capital, you have to comply with agreements, and you have to comply with law. So there are a lot of independent circumstances that prevent that type of activity. If this was rampant, we'd see a lot more of it, and we don't. I mean, we can all speculate what might happen or if this happens, but by and large, oil and gas companies try and comply with the law, work with consultants and lawyers and people to meet law. There's always bad apples in every industry. I think if we looked at the coal bed methane industry up in Wyoming, we could point out bad apples that came in from Michigan and created problems. But those people are found out, they're pursued, and maybe we need new laws. But again, as you saw in my presentation, we are getting new laws, and they're becoming more restrictive, not less restrictive. And so regulatory agencies in Congress, states, are listening to the concerns of the people and the issues that are being raised, observing them for themselves, and they're addressing them through regulation and law. So I think that's the whole beginning of my talk. You know, we are a nation of laws, and I think that's something we can be proud of.
Staying in a challenging tone here, all the questions get addressed here. From this lecture, I gather most fracking polluting is legal. If killing children were legal, would it then be reasonable to support that?
Well, I think I would call that question kind of a smart-ass question. So I didn't say that. And it's just like any kind of activity, the fracking that is going on, the oil and gas production that's going on is being regulated under law. And so the premise of the question I struggle with.
What about flaring?
I think flaring is a very interesting issue and problem that is also undergoing a lot of regulatory change. North Dakota in particular has the U.S. largest fracking problem. And they just... Flaring. Yeah.
You said
flaring.
fracking.
I know.
Yes.
I've got F on the mind.
Yes, well, don't go too far with F words.
I won't. So anyway, flaring is a problem, and part of it is when you produce oil or natural gas. If you don't have the pipeline infrastructure there, particularly in North Dakota, they're producing oil, they're flaring off the methane that's associated with it. That is throwing a lot of methane into the air. This isn't good. But when does the infrastructure get built to catch up with that? My understanding, two of the lawyers in my office are actually doing a paper for the Rocky Mountain Mineral Law Foundation this summer, which is an event Patty is keynoting. And they're looking at the new flaring regulations in the different states and federal regulation. And that is what that BLM onshore order number 9 I was talking about. That is going to be addressing federal regulation of flaring. But again, it's a balance between economics and environment, because what are you going to do with the flared gas? Where does it go? If you're out in the middle of nowhere, not next to a pipeline yet, can you require someone to build a pipeline to who knows where? So that is something that is a current issue, again, related to the methane issue that is being addressed.
What do you think of Diana DeGette's FRAC Act? Do we need to close the Halliburton loophole?
I don't think we do, and so that's not surprising. I don't think that act is necessary. I think the judgment call that was made in the Clinton administration and carried on through is an accurate one. And that is, again, it gets us back to our federalism. States are regulating this practice. She wants federal regulation. The states say, no, we have regulated this practice. We have a robust system in place. We want to keep regulating this technology and protecting the aquifers. We can do it. We've proved it. Now, I think what will happen is we're going to have the EPA report come out at the end of 2014. That may change EPA's position. That may add support to Diana DeGette's bill. But I'm not in favor of that bill, not surprisingly.
The oil and gas industry has far larger financial strength to hire legal expertise than does the general public. How can a level playing field be achieved?
Well, I would say that the general public has non-governmental organizations, which include the Wilderness Society, NRDC, the Earth Justice Legal Firm, Center for Biodiversity, many different organizations who refer to themselves as citizen groups, so they feel they're representing the citizens. Nobody has to pay for them except the party that, well, the federal government pays for them. When they win a case, the federal government will pay their legal fees. But there are those groups out there that represent the public. All right. And then, as far as local people having an issue with their local property and having to hire a lawyer, yeah, that is a burden. Lawyers are expensive. But I think there are opportunities for citizens to band together, which they've done in states, so that they have one lawyer that's paid for by, say, 20 families in the area that are looking to lease their land or are looking to hold the oil and gas companies to account. So they're not left completely bereft. And they have the state and federal agencies that also represent the views of the public.
If the oil and gas industry does not try to skirt around laws, what is the point of a lobbyist? A lobbyist would not go to talk to a politician about an existing law that they don't want to change, so a lobbyist must be there to push for laws.
Yeah, that's correct. That's why they have lobbyists, is to advocate for new law, change law, but they don't lobby the government to not comply with permitting requirements. The permitting requirements are in place for your particular process. You have to go through that. You work with the agency to see how you can comply with the process. You don't want to over-comply. Agencies always want to expand their turf. The Fish and Wildlife Service wants to regulate endangered plants on private land, except guess what? They don't have the legal authority to do that. You can destroy endangered plants on private land. It's not protected by the Endangered Species Act. So you have lawyers representing you to make sure the agency doesn't go over their jurisdictional authority. But lobbyists are there to advocate for laws not being changed. There's a lot of oil and gas lobbyists back in Washington saying, hey, don't change our tax benefits that we have, just like the wind industry is back there lobbying. But my point is that when you're going through a regulatory process, you don't bribe somebody to look the other way, and you don't lobby them and say, oh, please, come on, don't make me get this Clean Water Act permit. No, but you do lobby to change laws, and that's our right to petition the government, and all of us have that right.
Why the rush to get oil and gas out of the ground?
The oil and gas industry responds to demand. Right now, oil prices are comparatively high, and that's just what I would call economics 101, supply and demand. Right now, we have so much natural gas, prices are down. So there's not the same incentive to go after natural gas in the western areas because the transportation costs count against us. Oil is more valuable now. So oil and gas companies, you see Encana shedding assets. They were a natural gas company. Now they're moving away from that, to move into oil because that's where the money is. Oil and gas companies respond to our demand for energy. They don't just develop energy, hey, let's make a buck and develop oil and gas and maybe somebody will buy it. No, they're responding to the marketplace. We demand oil and gas. That's why it's being produced.
What challenges does the industry face in complying with overlapping and possibly conflicting federal, state, and local regulations?
Well, I think that's the complicated arena, and why you end up having all these consultants and lawyers is trying to help companies navigate compliance with state and federal statutes. I remember when I was in Montana working on mining, this was before computers really got going and Excel spreadsheets. But we had a big chart on the wall where we had graphically illustrated the various permits we had, the state NEPA process we had, and how to coordinate them so the studies and compliance with this statute got done in time to inform that permit process. And it's complicated. And there's no two ways around it, but that's our system of government. The founding fathers had a healthy suspicion of human nature. So we have our government split into three layers. We've got federalism with state and federal, and I think it acts as a check on any one government getting out of control.
How much are regulations evidence-based, and how much are they based on things other than scientific research?
Well, that's a good question. I think with anything, the development of regulations is also a political process. So they are based on scientific information to a certain extent, but nothing is ever purely science. Science is not in the business of answers. Science is in the business of questions, asking that hypothetical to prove if something's true or not true. So I think that science goes into it, particularly in EPA regulations. If you go onto their website and look at their interim report on the EPA fracking water issue, those studies that they're doing would make your eyeballs cross. I mean, they're very, very technical. And BLM, I would say, is not so technical. They're a land manager, after all, and doing oil and gas. But the fracking regulation is also technical. But people weigh in. People will say to EPA and BLM and say, whoa, this way you've written this regulation is going to cost too much. And you should do it this way. Or don't do it at all. So there's opportunities there to address the content of regulations politically, because it is always a balancing. Again, the last slide with President Obama. We want to promote jobs and the economy, but we want to have good regulations. The two are not separate.
Who is in the best position, what agency who or what agency is in the best position to regulate oil and gas production, or which level of jurisdiction?
Well, I guess I would say I like the system the way it is now with the state conservation organizations regulating the downhole, working with the land managers on the surface. I think that's appropriate. They have the technical expertise. If you wanted either BLM or EPA to regulate oil and gas, you would have to have a whole new department. In the case of EPA, you'd have to have a whole new group of employees at BLM. And in fact, there was just a report from the GAO just 2 weeks ago or a week ago saying BLM right now can't keep up with the oil and gas industry and keep good people because they can't pay them the amount that the people can get in private industry. So that's a struggle.
How does an attorney, an experienced attorney, respond to initiatives in collaboration, cooperation, dialogue? Something that goes outside of litigation, in other words? How does an experienced attorney say, stay in the courts, or?
All right, I've got the question.
Okay.
Yeah, I think most attorneys don't counsel their clients to go in the court. Court is expensive. Court is a crapshoot. You don't know what the answer will be, so it's a risk-reward proposition. Most of the time, companies don't go in and litigate. They do in some instances, but they may intervene into a lawsuit that an environmental group files against a federal agency that has issued them a permit. I'm a big believer in working and talking to people. I think we don't do enough of that. And I would say the oil and gas industry has not been a good communicator with the public. They are engineers by and large. Their training is the training of an engineer, black and white. Numbers, technology, and science. That's what they're comfortable with. That's why they went into the business. They're geologists. They like to be outside. They are not, and the BLM is the same way. They're not comfortable communicating with the public either. That's not what they signed up for. But we need to do that. And so in my role as a lawyer, I try and counsel clients to the extent I can to work with people and talk to people, do public communication, but they don't always agree. Again, they're not comfortable with it. But I have been engaged in efforts and have worked collaboratively. I worked with Southern Utah Wilderness Alliance on a case just 2 months ago, and we worked together, my client and SUA, and resolved our differences, and SUA did not protest my BLM APD permit for my client at all. We came to an agreement. And that was great, because my client was a startup company, a producer of helium. They couldn't have gone through litigation and all that fuss. They wanted to get on with their business and get going. And we were able to work together and find a mutually agreeable solution, and we both went away happy with that.
Okay, well, ladies and gentlemen, join me in thanking our speakers.